Welcome to the Federal Bar Association, Northern Virginia chapter, and the Metropolitan Washington Employment Lawyers Association's December webinar, Picking Your Fights, How to Avoid Discovery Disputes That Do More Harm Than Good. I'm Scott Oswald. I am MWELA's Bench Bar Committee Chair and your moderator for today's program. Before we begin, Carla Brown, President-elect of the Federal Bar Association, Northern Virginia chapter, has joined us. And she's going to tell us a little bit about what we can expect from the FBA Northern Virginia chapter. Carla?
Thank you, Scott. I just want to thank MWELA and you, Scott, for allowing the Federal Bar Northern Virginia chapter to co-host this event with you. If you're not a member of the Federal Bar, we put on a lot of excellent CLEs and have a great relationship with the court. Of the highlights of the events that we do during the year include an admission ceremony. So if you're not admitted and would like to be admitted, it's an opportunity for you to do so. That's usually followed by a welcome to the court, which we're lucky enough to have usually most of the bench participate, and the various offices of the court will explain to you what they do. It's a great event. Every year I learn something there, as well as the state of the court that's given every year to let you know what it's looked like for the court over the last year, and the annual Tori Armstrong seminar, where you'll have an opportunity to meet the incoming law clerks that work with the judges of the court. So we have some outstanding events. If you're not a member, please look into joining the Federal Bar Association or the Virginia chapter. And if you're not sure how to do that, please feel free to reach out to me. I'd be happy to help facilitate your entry. So thank you for having us. I'm looking forward to a great seminar today.
Carla, thank you. And now to our participants in today's roundtable. First, the Honorable Mark Coulson is a magistrate judge with the U.S. District Court for the District of Maryland. Judge Coulson has served as a federal magistrate judge since 2014. The Honorable Ivan Davis is a magistrate judge with the U.S. District Court for the Eastern District of Virginia. Judge Davis has served as a federal magistrate judge since September 2008. Andrew Adelman is an attorney with the law firm of Correia and Puth. Andrew represents individuals in all aspects of the firm's civil rights and employment litigation practice. Lauren Goetzl is an attorney with the law firm of Fisher and Phillips. Lauren represents and advises employers in all areas of employment law. I'll take your questions throughout today's program, and at the end, we'll run from now until just before 1:30 Eastern. Just use the Q&A button located at the bottom of your Zoom screen. Let's begin with the current state of court operations in the Eastern District of Virginia and the District of Maryland. Judge Davis, I'd like to begin with you. On July 5th, the court adopted an updated masking policy, which continues to be division-specific. What's the current status of hearings and trials in the wake of Chief Judge Mark Davis's most recent orders?
Well, we're back up to full force. Any time any judge obviously has an absolute right to implement their own specific policy, either for their chambers or for their courtroom. To the best of my knowledge, though, however, I don't believe there's a single judge, whether it be a magistrate judge or a district judge or anywhere in the court at this point in time, that are requiring masks or any distancings in their courtroom. I don't know about obviously their chambers, but at least for the courtrooms.
Judge Coulson, on September 29th, the court ordered all those entering the courtrooms to wear KN95 or N95 masks. Same question, what's the current state of hearings and trials in the wake of Chief Judge Bredar's most recent set of orders?
So I would say we're very much like Judge Davis described in his district. The one difference I would say is when you are coming into a courtroom, you do have to have a mask. You then may remove your mask while speaking. And of course, individual judges can change the rules if they would like to do that, either to have more masking or less masking. But otherwise, we're basically up to full strength. I would say the one difference from pre-pandemic times is that our jury trials are being centrally managed. The calendar is being centrally managed, which is something new for us. But we're doing that to accommodate some of our remaining COVID precautions jury selection is a little bit more resource intensive and cumbersome. So we're not quite able to run our full range of trials. In the old days, we could have 8 trials going in this building without a problem. Now we've got a little bit of a restriction. Frankly, though, since most cases resolved by settlement, I think we only had 16 civil jury trials in 2019. It's not that much of a change from the outside looking in.
Okay, let's turn to avoiding discovery disputes at the beginning of the formal discovery process, the 26F conference. And Judge Davis, I'd like to begin with you. What are the most important things that parties should discuss at the 26F conference to avoid later discovery disputes?
Let's just say from a rational standpoint, the most important thing probably to be discussed is the possibility of a prompt settlement, because if the case is over, there's no possibility of any discovery disputes. But seeing that probably may not happen in most cases, obviously, and one of the things that a lot of people discuss, which in this district they don't deal with much anymore, is consent to proceed before a magistrate judge. I believe, and I believe my colleagues believe, that the most important thing is to ensure that whatever discovery plan you submit to the court will conclude discovery by the discovery cutoff date set forth in the district judge's initial scheduling order. There appears to be more than enough occasions in which I think the parties don't believe they can get that done. And so they agree to a discovery plan that sets the dates outside of that date. And it's a magistrate judge can't approve that plan. It's just that simple. We must approve a plan that concludes discovery by the discovery cutoff date set in the district judge's initial scheduling order. So I would probably say that's the most important thing besides prompt settlement.
So talk to us about consenting to a magistrate judge, not just for the motions practice, which would be before you any non-dispositive motions, but also maybe for trial. What's the advantage of doing that in the Eastern District?
Well, we seem to have gotten more trials in the last couple of years. We don't really know why that is. So obviously the old rule that used to stand, which people don't believe stands anymore, is that you probably would get a faster resolution to the matter if you consented to proceed before a magistrate judge rather than a district judge, since they seem to be having a few more trials, both on the civil and the criminal dockets these days.
In that 26F conference, is it important to talk about expert disclosures and when those might occur? And what do you expect the parties to include in that draft discovery order that they send to you?
Well, yes, that's an important part too. I think that just goes back to what I was saying earlier. For some reason, there have been a lot of parties that believe that the discovery cutoff date set in the district judge's initial scheduling order deals with fact discovery. It does not. It deals with all discovery. So when you're talking about experts in that plan, you need to ensure that the expert discovery will be cut off at that date as well. That means the provision of the reports as well as the depositions. And that's where the court believes the party should think about it a little more, because I've seen, I believe, too many reports that may have the final rebuttal report due a couple of days before the discovery cutoff, which of course, from a logical standpoint, doesn't really give you any time to depose the expert. And so that will be an issue, because then you're going to have to submit a motion. Then you're going to be at the hands of the magistrate judge on why we didn't set those dates a little earlier. But you don't have to worry about that with me, because if I see that in the plan, you will probably get a call from Chambers saying you probably need to change those dates and move them up.
Let's turn to proportionality, the proportionality provision of Rule 26. Judge Coulson, I'd like to begin with you on this topic. Federal Rule of Civil Procedure 26B1 counsels that the scope of discovery should be proportional to the needs of the case. How does this apply in an employment case where equitable relief may be an important component of the requested relief from your perspective?
I used to say when I was still practicing that, I never met a balancing test I didn't like, because I could always, use it in my advocacy. And certainly we see that when we start talking about proportionality, people take the factors and forgive me, spin them however it helps them the most, and I wouldn't expect them to do anything else. So what I try to do is I keep the focus on relevancy, and I keep the focus on reasonableness. And yeah, that can well include equitable considerations. I don't just look at how much money are they asking for. Frankly, most of the time they're just telling me it's beyond the jurisdictional amount. So it's hard for me to make that assessment. But the more likely the discovery is to get at what I'll call core relevant information, the more likely I think it's going to be proportional to the needs of the case. So I don't just look at what are they fighting about. I look at what is the goal of discovery. The goal of discovery is to have an efficient and expedited process to get to the most relevant information the quickest. And I kind of use that as my rule of thumb, if you will, as I'm deciding these proportionality issues.
Thank you. Judge Davis, where do you come out on this in terms of the proportionality requirement of 26B1? How does that translate generally into your view about the scope of discovery in an individual?
I generally concur with Judge Coulson. I mean, I think that we have to always consider that rule, the first rule in the federal rules, and that is, of course, I don't know if they said it quite appropriately when they say inexpensive, but at the very least, the least expensive litigation that's possible. And when you think about it, you should think about it as the old saying goes, place yourself in the other person's shoes, because if they turned around and did something that would make things a lot more expensive for you, well, let's say for your clients, then obviously you would not probably think that's proportional. Now and I completely agree with Judge Coulson when it comes to the relevancy issues. If it gets more to claims rather than damages, and it gets to damages rather than the amount of damages, like saying we're just trying to get information that will increase our damages even more, as we go down that road, the court believes that we're becoming a little less proportional to because it doesn't say what we want. It doesn't say the desires of the case. It says the needs of the case, and the needs are to prove the elements first. So
thank you. Let's talk about timing of discovery in relation to the 26F conference, and in particular, commencing discovery in relation to that conference. So there was a time when discovery could be served with a complaint. Now, consistent with 26D, discovery can't commence until the 26F conference. Judge Coulson, when should the 26F conference occur in relation to the scheduling conference date?
Well, that's a great question. And in our district, we basically exempt parties from the 26F conference and from 26D timing. So what do we do instead? And why do we do it that way? All of the discovery and the timing of it is going to be key to the scheduling order. So the scheduling order will issue immediately after an answer is filed. So if you respond to the complaint with a motion, that's going to be dealt with before a scheduling order gets issued. But eventually, once an answer gets filed, you get your scheduling order, and that's going to have your presumptive deadlines for all of these steps. In effect, we kind of have your 26F conference for you because we make a lot of decisions on those issues, disclosures, how many depositions, things like that, presumptively in that order. And then most of our judges will schedule a telephone conference very shortly thereafter, so they can basically run through those items in the scheduling order. No discovery may be sent before the scheduling order issues, so everything really is key to that. So why do we do it that way? Why don't we take advantage of the opportunities in 26F and the Rule 16 conference with counsel? So we have about 3,500 cases at any given time, about the same number come in and out every year. So we never really make a ton of progress on getting that number down. But most of the time, everything goes fine. Most cases don't have discovery disputes. Maybe 10% have discovery disputes. So the feeling was, and this was with feedback from our local bar, Why would we make all, say, 3,500 cases, meet on the 26F, come up with a discovery plan, meet and confer, and instead we basically have put in an initial judge conference to set the tone, and then a self-help model if you run into problems. The trade-off is, if we're not requiring the conference, well, aren't we going to have cases that become a mess? So the trade-off that we've instituted is that we have an expedited discovery dispute process. So if you do run into a problem, you can get to usually a magistrate judge, but you can get to a judge quickly, and we can get that dispute most of the time completely resolved within a few days. So that's been our approach. It seems to be working well. Obviously, there are going to be cases where the judge in that initial conference is going to be more hands-on and will be more encouraging to the parties to meet and confer, particularly with ESI and issues like that. So there's always the order says something like, you don't have to do the conference, but you're very encouraged to talk about the following items, basically, which come out of 26F and Rule 16.
Judge Davis, how about in the Eastern District? When should the 26F conference occur in relation to the scheduling conference date?
Well, it's interesting the way the District of Maryland handles that. We also, I believe, the initial scheduling order from the district judge says that discovery can begin at the date of the order. So you don't have to wait, as the rule says, until the 26F conference and therefore the initial pretrial conference to begin discovery. Unlike the District of Maryland, however, we do still require the 26F conference, and the parties can meet and whenever they feel like it, as long as our rules require us from the magistrate judge's point to submit your proposed discovery plan 1 week before the initial pretrial conference, which is of course set by the district judge. So whenever you want to have the conference is up to you, but obviously you must have it before 1 week before the initial pretrial, because that's when you're required to submit your joint discovery plan. And so that's how things work in the Eastern District of Virginia. We don't utilize telephone conferences like they do in the District of Maryland, but it is true that most people opt out. We've started suggesting to them that that they should deal with in their joint discovery plan whether they wish to opt out of the initial pretrial conference, because we found over the years that if they agree to majority of the information contained within the plan, then there's really no need to have the parties come to chambers to discuss something that they pretty much agree to. So I would probably say in 95+% of the cases, we do not end up having the initial pretrial conference.
Judge Davis, thank you. Let's turn to timing and discovery. Andrew, I'd like to bring you in at this point. If you have multiple venue choices, as often we do in employment cases, do you choose a venue based upon when you can serve formal discovery?
That's certainly one of the considerations that we're thinking of in terms of where we're going to file our case. With respect to in federal court or state court, at least here in DC, which is where our firm is located, our state court and our state rules allow for service of discovery with the complaint. And so that allows us to really get out the gate as soon as our complaint is filed and get discovery to the other side. And that's certainly a consideration for us as we want to move a case and push a case forward as quickly as we can. The federal rules now allow for the service of at least document requests early. And that's something that we are certainly taking advantage of to the extent that we can, be it in federal court in DC or in Maryland. I'm not myself practicing in EDVA, so can't speak to that forum. But, to the extent for us, to the extent that we can get our discovery to the other side and get defense counsel looking at our requests and the scope and beginning those conversations as soon as possible, that's an advantage, and that's a way to really try to narrow down any disputes before we have to get to the court, if at all.
Andrew, thank you. Let's turn to the gathering and production of electronically stored information. Judge Davis, what are some of the common mistakes that you see lawyers make when gathering and producing ESI?
A lack of discussion, essentially, on either the form or custodians. I mean, the biggest dispute we normally get is the number of custodians. And that's, of course, we have a local rule that requires the parties to meet and confer in good faith before bringing any, in person or by telephone, before bringing any disputes to the court. But when it comes to ESI, those are the biggest concerns. And the reason I say that is because when we're talking about form and we're talking about the number of custodians, we get back to the amendment of the rule, Rule 26, because that's when we hear most of our proportionality arguments. And I think it's because people need to get together and understand what each party's capabilities are in regards to how we can utilize ESI. I mean, the different systems, different people have different vendors, they have different computer capabilities. And we've literally had disputes over people who have sent ESI and the other party said we couldn't open it. That seems a little odd because you think that's something you would discuss before going through the process of putting together all of this information just to have to do it again. So I think form, how we're going to produce it, of course, whether it's native format, which you don't see often, including metadata, but if it's necessary, that's something you should discuss in the future. And of course, the number of custodians, because that's a big part when it comes to proportionality, because can be a huge difference between what 3 custodians have and what 10 have.
Thank you. Initial disclosures, Judge Davis, is it ever a good idea to waive initial disclosures in an employment case?
I have not understood a case in which waiving initial disclosures would be beneficial. I mean, not in an employment case. In cases involving the government and administrative things, that's another whole story. But I mean, the purpose of initial disclosures is to acquire information that can start the process, get you delving into more in-depth information earlier. So why, especially in the Eastern District of Virginia, where we're so fondly known as the rocket docket, I don't know why you would want to waive initial disclosures when it can provide you information on how to form, the specificity of your interrogatories and all of the rest of your discovery requests. But I'm all open to ears if someone can provide me a situation in which they think it is beneficial. I have not yet heard of one.
Thank you. Let's turn to discovery tools. Lauren, I'd like to bring you in at this point and talk about your favorite discovery tools as a management side lawyer. Give us a peek behind the curtain.
Sure, Scott. So, beyond obviously your standard interrogatories and requests for production of documents, I really like to use subpoenas duces tecum to try to get some information from third parties, be it post-termination employers about damages information, be it mental health professionals about emotional distress. I think that those tend to be very helpful sources of information as well when trying to put together a picture as to what happened to the plaintiff and what we're looking at in terms of potential damages as well, to inform settlement discussions eventually as well.
Thank you. And the subpoenas that you're issuing, are you issuing them to all medical providers, a certain subset of medical providers? How does that work? How do you walk through that process?
Sure. So yeah, it obviously depends upon the individual case. In a disability discrimination case, obviously we would want information from medical providers who've treated the individual with regard to the disability, particularly obviously at the time of the relevant employment decision. If it's something else, if it's sexual harassment, whatever it might be, then we're more focused on the emotional distress witnesses, the mental health provider. So it's obviously going to depend upon the individual case. And also, if you have a witness who says that they didn't seek any kind of medical or mental health assistance with regard to emotional distress, then, that's a situation that we wouldn't necessarily need medical provider documentation, again, depending upon the individual circumstances.
Thank you. Andrew, back to you for a minute. From the employee counsel side, what are your favorite tools to use in your cases, the discovery tools that you go back to over and over again?
I really think that informal discovery tools are something that we can continue to mine and can be really a wealth of information that we don't often take as much advantage of as we can. Standard interrogatories and requests for documents give us so much information, and to some degree are at least interrogatories are attorney crafted responses our clients, for us at least, are going to be the experts of the workplace, and they're going to know the people and the information that we need, and be it, using them to access other coworkers who might have information and serve as possible witnesses, to be able to identify where documents may exist or who has documents, text messages or social media accounts that might have relevant information, or to the extent it was used or not. They're going to be, the wealth of information that we can use to then go to either a defense counsel through formal requests or to informal discovery efforts to find the information that we need.
When could a Rule 34 site inspection be helpful in an employment case?
That's something that I've always wanted to use, but haven't actually myself had the opportunity to do so. And I think it could be certainly something that we take advantage of. I think specifically for a disability discrimination case where accommodations might be at issue, or the physical work site is something that is of a value in determining whether accommodations were provided or not. Taking a tour of the work site to understand what the physical needs and space look like can be incredibly valuable. Another example is, for example, in a harassment case where, the proximity of people's office locations or the routine path that employees walk or may go throughout the day could be valuable to try to understand, what the interactions of individuals were and how often they occurred. So yeah, I'd love to do one day. I just, myself haven't had the opportunity to do it.
Thank you. Lauren, I want to turn to you and just talk a little bit about process for a minute, in particular, the process that you go through to answer Rule 34 requests for production of documents. You get those, let's say they were served with a complaint in DC Superior Court from Andrew. Just walk us through your thought process. How do you go about approaching the responses to the Rule 34 request for production of documents?
Sure, Scott. So when we get requests for production of documents, I'll take a look through them. Based upon my knowledge of the case, I will either craft a list of requests for the client, or, if it's very early on in the case, if they're literally served with the complaint, as you were referencing in DC State Court or Superior Court, I'll reach out to the client and try to schedule a call so that we can put our heads together to make sure that we're collecting all of the relevant documents, and kind of proceed, collect information, see what else we might need, and kind of, go back and forth in that process.
Do you have your IT professional gather email communications?
It depends upon the size of the client. So obviously, if it's a smaller client, we may hire an outside vendor to help us out with that. If it's a larger client, they might have their own IT professionals. But yes, as early on as possible in the case, I like to try to think through ESI and what might be relevant, both to inform my own investigation and view of the case, as well as obviously to respond to requests for production of documents.
A decade ago, there was a saying, it's all in the email. I think now it might all be in the instant messages. Do you gather instant messages, Slack, et cetera, from your clients? And how do you approach the gathering of instant message information any differently from email communication?
We don't handle it, or I don't approach it any differently personally. So, same sorts of things in terms of custodians, time periods, search terms, and we obviously collect them at the same time as collecting emails, and try to really provide a fulsome search as well as a fulsome review to get a better picture of the case.
In terms of the gathering of this information, do you have the let's say an IT or professional do it? Do you ask the individual custodians to get it together and send it to you? How does that work?
We always have some sort of IT professional generally do it. So whether it's somebody in-house, as I said, the company's large enough that they would have their own IT professionals, or if we have an outside vendor that's going to work with, usually there's somebody in IT who can help us out. But generally we go and collect the documents or the emails themselves. We don't rely upon the individual custodians to do so.
Thank you. Let's turn to cell phone information. Andrew, do you routinely collect pre-suit your individual clients' cell phone data?
Once a client comes to us and we've decided to take the case, as early as on the first couple of meetings with them, we're asking for essentially everything that they have, we want to have, because the last thing we want to happen is halfway through the line down in the case, our client gets another cell phone or something happens to the data and it gets lost, and we haven't done our due diligence in trying to collect that as soon as possible. So we're typically downloading our client's cell phone data to the extent that we can, and at least, containing it on our hardware, our systems, so that we have it. In some circumstances, it's relevant and there could be stuff in there. In other circumstances, there's not, because our client didn't communicate by phone or text or on their device with, or have relevant information on there. And so we certainly want to have it, cell phone data, social media information, which is becoming more and more a tool that folks use to communicate with coworkers. We're trying to get all of that as early as we can, both to make sure that we're preserving it for our discovery obligations, but also so that we have an understanding of the facts of the case and can, draft our complaint and draft our discovery request to be really targeted to the information we need.
And the cell phone data, do you use an outside vendor? Do you do it in-house? How do you collect that information?
Usually, we found tools that we can do it in-house. We're, a smaller firm, a bit scrappy, don't have all the resources that the bigger firms do. And there are a lot of, really inexpensive tools out there to collect iPhone data. Android data is a little harder to do, but there certainly are some tools and steps out there. That's something, we've trained ourselves to be able to do and collect and preserve, and to be able to analyze and sift through on our own. So we're doing that all in-house typically. If there is more complicated stuff, or if there is a need to preserve, for example, an external hard drive for forensic purposes, we may consider external vendors to do that. But, that's, I think, the more rare occasion.
You mentioned social media. How do you gather that information?
I think when social media became particularly relevant, I think, or more predominant a couple of years ago, there was a bit of a trying to figure out how to get it done. Most social media sites have an opportunity to download someone's social media entire profile or all their information. And so that's typically something that we'll ask our clients to do if there is going to be data on there or relevant information on there. If there are it's just a couple of messages, or if there's just a couple of posts or whatever the case may be, it may just be screenshots, because social media does have a lot of personal information, most of which is not relevant to the cases that we're pursuing.
Medical records. Lauren mentioned the fact that she will issue subpoenas to medical providers. Do you gather a client's medical records at the outset of a case?
Yeah, that's absolutely something we're doing, again, to the extent that it's relevant. If it's a disability case and our client saw providers, presumably they did, or if there's emotional distress and a mental health provider that has relevant information, we're gathering that, hopefully in an effort to kind of head off the subpoenas that we typically and often do see in our cases. Because if we can gather our clients' information and produce them in the course of discovery, the last thing that we want is defense counsel reaching out to these providers to get the same information that we're otherwise able to provide them without the need for that extra work. We think, that level of, we think our clients' medical providers often have, particularly private and sensitive information, a lot of which isn't relevant to the cases. And, to the extent that we can ensure that the medical information that's being used in the cases is really relevant to the issues at hand, be it, a disability or emotional distress considerations, we want to try to focus it and narrow the scope of those requests.
Laura, what about that? If Andrew gathers that medical documentation and is ready to produce the relevant medical records to you, does that then obviate the need for a subpoena or a HIPAA release to the medical provider?
It depends upon the circumstances of the individual case, Scott. So, there are certainly cases in which that is sufficient, and we're happy to accept that. There are times, as well, where the information that's provided is not to the extent of what we would request from a medical provider. So, for example, if we need to know dates that they went to their medical provider, sometimes the information that we get from plaintiff's counsel may be summaries of visits, but it may only be the major visits. So perhaps it doesn't have all the dates, for example, that a plaintiff went to their medical provider. So, that's a situation in which we might then need to serve a subpoena. or sometimes we'll sometimes see situations in which only a certain time period has been requested and we need a larger time period. Those are certainly things that we would discuss with opposing counsel and potentially still need to serve a subpoena duces tecum to resolve.
Thank you. Andrew, back to you. Tax returns for your clients. Do you ask for them at the outset of a case?
Typically not. Frankly, I think our position is the tax returns are themselves irrelevant in these types of cases. To the extent that our clients' interim earnings after, if there's a termination involved, is relevant, we're happy to produce W-2s or other proof of subsequent earnings. Tax returns have a lot more than that and contain a lot more information than that. And I think there's absent a showing of a need for that specific information. We're not collecting them and we're not producing them.
Lauren, how about that? If plaintiff's counsel submits to you, let's say W-2s from their subsequent employers showing their income that they have for those employers, is that sufficient for you to put together what you need from your perspective?
Again, it depends upon I don't mean to sound like a broken record, but it depends upon the circumstances of the case, Scott. I think, oftentimes that will be sufficient. There are many times where tax returns are helpful in the sense that, I can't tell you the number of times I've gotten to a deposition and all of a sudden found out that there was another source of income that I didn't get from the plaintiff before the deposition. So the number of people who drive for Uber or Lyft who don't consider it a form of income, before their deposition or something like that. So in those sorts of circumstances, sometimes the W-2s are great. And sometimes we have reason to believe that there might be other sources of income that are not covered by the W-2s. And in that situation, we might ask for something different, be it bank account statements or tax returns or something like that to be able to get a better picture.
Lauren, subpoenas to a plaintiff's current or former employers. When do you issue them? And just step us through the thought process there.
Again, it depends upon the individual circumstances of the case, but if we're not getting information about post-termination damages, income, that's a situation in which we would need to subpoena those types of documents to be able to get a sense as to their post-termination income. The more forthcoming plaintiff's counsel can be, the more willing the more willing we are to avoid doing that. So if we feel like we're getting a full picture as to post-termination income, then we don't necessarily need to do that. But oftentimes, if we're not getting that type of information, or if we have some reason to distrust the plaintiff, then we might need to subpoena those types of documents.
Let's turn to imaging the cell phones of your supervisors at the company. Warren, do you, let's say in a discrimination case, routinely image the cell phone of the manager, the individual who made, let's say, the employment decision? Do you image their cell phones?
We typically will wait for some sort of request for that documentation. Oftentimes, that obviously involves some sort of third-party vendor, and oftentimes, honestly, it's a challenge to do so given the passage of time and just the nature of technology and when that sort of information is retained. So we will typically wait for a request if the plaintiff has reason to think that there might be some individual who might have text messages or something that are relevant. Then we're certainly happy to explore doing that, but it would take a request from the plaintiff to initiate that.
Thank you. Judge Coulson, I'd like to bring you in at this point. In a single plaintiff case, when is it appropriate to seek phone data from corporate decision makers in addition to email?
Well, it's kind of the same criteria I would use to determine when it's appropriate to seek anything, right? So if it's a case where someone's alleging, for example, my manager was harassing me and sending me obscene text messages, well, then that makes it pretty easy. If it was, I got worse shifts than my comparator, if you told me that it was very routine that people are texting and that's how we handle our business communications, you know, you might be able to make that case, but you know, it's certainly not going to be a yes in every case. You know, I'm looking for you to tie in, just like with anything else, tie in for me, whether it's an extra custodian, whether it's an extra personal device, an extra computer system. Tell me why we think that there's likely information on there that we don't otherwise have access to.
Thank you. Judge Davis, same question. In a single plaintiff case, when is it appropriate to seek phone data from corporate decision makers in addition to email?
I would have to concur with Judge Coulson. In fact, I found this entire discussion somewhat interesting because I don't believe I've ever gotten a discovery dispute in regards to someone not acquiring any information from a cell phone. When you talked about, Scott, instant messages, the first thing that came to my mind was, what about text messages? And I haven't seen any disputes concerning text messages. I guess I would use the same criteria as Judge Coulson. My first questions, however, would be, what phones are we talking about? I mean, are we talking about employer-issued phones, employer-issued telephones that are supposed to be used only for employment-related information? Are we talking about personal cell phones? And just like Judge Coulson said, what information do you have in your possession that would suggest that this individual used a personal phone over an employer-issued phone in order to acquire that information? Because that may be one of those few circumstances that I would think someone might more appropriately use a subpoena to a third party, that being the issuer of the phone, Verizon or someone, because, you know, if someone sent a harassing text message or something like that, you know, every device has its own IP address and those types of things. And you can find that instead of getting involved in disputes, trying to get information from someone's personal phone, if you don't have any information in your possession that suggests that the harassing text message or phone call or whatever came from a personal phone. So until you can prove to me where it came from, almost, I'm not going to say prove, but at least a prima facie case on why that information is where you believe it to be, you're going to have an uphill battle.
Thank you for your brutal honesty. All right, other categories of documents where disputes commonly arise. Let's talk about tax returns. We touched on this. Judge Davis, I'd like to begin with you. Under what circumstances will you order an employee to disclose their federal or state income tax returns to their employer in litigation in an employment discrimination dispute?
I would tend to concur with Mr. Adelman on this one. I mean, I would suggest that parties try to acquire that information otherwise rather than going straight for tax returns. I mean, if all we're seeking is information concerning income, he's right. We have W-2s, we have 1099s, we have other ways to get that information. Tax returns have a lot of personal information on it. And then we get involved in the process in which they may be joint tax returns and spouses' private information may be on it. And you know, unless that's core to the elements of the cases, if you're just trying to prove mitigation and income and those types of things, you really have to show that what you acquired from them, somehow you have information in your possession that suggests the information you got to them from them is incomplete or inaccurate. Because otherwise, we go back to that old statement that we hate as judges to use, because we know that no experienced, competent counsel will be trying to conduct a fishing expedition because it would be inappropriate. But, you know, if you can prove to me it's not, then of course you would get it, because, you know, it's a lot of discretion and the discovery is a lot more open than what's admissible in court. But you're going to have to prove somewhat that what you have, when you can't get from some other format what you want or what you have is inaccurate or incomplete.
Thank you. Judge Coulson, how about you? Under what circumstances will you order an employee to disclose their federal or state income tax returns?
Yeah, I'm not sure I have much to add to Judge Davis. I think we see this issue exactly the same. You know, it is a it's a blunt tool to try to get a specific kind of information, right? So you've got a form that's got everything from your social security number to your kids' names to your other assets and your charities and so on and so forth. And all we're really trying to do in most cases is to verify what your post-incident or pre-incident income was. There are lots of other ways to get to that, but there could be a case where that's the only thing that's left to us in order to verify. There's a question has been raised, a legitimate question has been raised, and we need those returns because they are likely to be very accurate. We may have a situation that arises, but you're going to have to make that case.
Thank you. Turning to medical records, Judge Davis, under what circumstances will you order an employee to produce her medical records in a garden variety emotional damages case?
Well, I mean, that's a tougher one. I mean, because what you're proving, you're just taking the stand essentially and saying, well, I didn't feel well, or this didn't happen, or if you believe you have some information in your possession that suggests that their medical records have some information that would suggest that their statements are not accurate, then that's one thing, because we can't go with a speculation or an assumption that an individual in a deposition, once they've taken an oath to something, is not going to be telling the truth. Now, obviously, you have an absolute right to try to prove that they're not, but medical records are quite sensitive. And if you're looking for them, your request better be very specific, because that's a incident in which we find a lot of issues when people are looking for medical records concerning any and everything, and we're only talking about something very specific. I mean, the probability of you getting some, how someone felt emotionally between this date and that date from some dental records is probably slim to none. So your request should be a little more narrow than all medical records and that type of issue. So it's rare. I mean, if it's in garden variety, because that's the reason they're saying garden variety. I mean, otherwise, if specifics are required to feel a certain way, and I would have to say that if it's something generally, their garden variety statements would suggest that that's something they may go see that normal people from an objective standpoint may see a doctor about, then there's a higher probability. I mean, if you're saying that, I felt so much pain from not being able to walk for 2 years, you would think someone will go see a doctor about that. And so, if you can narrow requests to try to get information that would suggest that that's not very accurate, then there's a higher probability of getting that information. Otherwise, you're going to have an uphill battle.
Judge Coulson, under what circumstances will you order an employee to produce his medical records in a garden variety emotional damages case?
Well, I think the same. What we're looking for is a specific connection. If it's a garden variety claim, we may have different definitions of garden variety, right? So, if someone testifies at deposition, I was very upset by this thing that happened at work, and in fact, I talked to my family care provider about it, right after it happened. Okay, so then maybe we'll get those records. But, sometimes folks will come in with a different discovery standard than the one I use. They'll be using the who knows, we just might find something standard. And my antenna is always up when it looks like that's the case. It's kind of the same thing with social media, right? Somebody's alleging that I was upset at work, and all of a sudden I get a request for all social media that they've ever posted on any platform. I mean, for what purpose, right? Number one, there's a certain amount of curation that goes into our social media presence, so I'm not sure it's all that accurate anyway. But number two, you catch me smiling at my kid's graduation doesn't mean that I wasn't upset that I was harassed at work, at the same time. So I'm looking for something pretty specific to suggest to me that there's something out there that is likely to be found, not people say things to their doctors and maybe they mumbled something that I might be able to take out of context and use.
Judge Davis, under what circumstance will you order an employee to produce her social media postings?
I would completely concur with Judge Coulson on this one. I mean, social media, people use it a lot. It's like I tell people a lot, like my daughter, it's like it doesn't, because it's on the internet doesn't mean it's true. So, I mean, you can get around ways to try to figure out whether something's true or not with cross-examination fodder rather than, because trust me, they'll have an explanation for whatever you find on social media anyway, probably. So you may not be doing your client any justice by spending all their money looking for a smoking gun in social media. But if you choose to do so, just like Judge Coulson said, you're going to have to give me something better than the fact that because people use social media a lot, there's probably something out there. It's kind of like in, agents' experience, and DEAs. In my experience, drug dealers keep their stash at friends' houses. Well, if I'm their friend as a judge, I surely don't want you knocking on my door. You're going to have to give me something more than that.
Thank you. Let's turn to comparator evidence. Andrew, I want to bring you back in at this point. Tell us about the best discovery tools for identifying comparator evidence in a way that you can actually use it at trial.
Again, I think one of the first and the best places to start is really your client. They're going to know the workplace and they're going to know the people in the workplace the best. And so, that's certainly a conversation we're having with them very early on. Oftentimes pre-filing about who are the people in the workplace, who are the people that perform jobs similar to you, who's being supervised by the same supervisor or in the same work site. And from there, using that information to craft both discovery requests and really narrow and specific interrogatories to get both identity of individuals and the documents relevant to either comparable discipline or disciplinary actions or commendations or whatever information may be relevant to prove the comparator. And in addition to that, it's really our informal discovery. Are we reaching out to helpful witnesses who know information that our client may not know because they're not, they don't have ears, they don't have eyes and ears in every aspect of the workplace or throughout the entire time that the supervisor or the management officials may have that may be relevant. And so, really trying to get as much information from as many sources as we can.
It sounds like you've got some informal discovery tools that you're working there, talking to witnesses, talking to others. How do you integrate that with the use of the formal tools that are available to us?
Sure. I certainly think it's two sides of the same coin. Our informal discovery efforts in terms of both using our client, but then reaching out to individuals and sources of information that might be relevant to the case. Oftentimes we or members of our firm are calling coworkers or third parties that might know information. Sometimes if it's a more complex case or more sensitive information, we might work with outside investigators to speak with third parties or witnesses to try to get and extract as much information as we can to then be able to either use that to our advantage in proving our case or crafting discovery requests to get to the information we need that we know that the company or defendant's counsel may have. I really think one helps inform the other.
Thank you. Lauren, how do you approach a plaintiff employee's request for comparator pay and disciplinary history information?
I think, first of all, it really depends upon the scope of the request as well as the size of the employer and kind of what we're looking at. Sometimes we get requests for, all charges of discrimination filed against an employer within a 5-year period. Well, if you have an employer of hundreds of thousands of employees with 100 locations across the country, that sort of information is just not relevant or responsive. And that's a situation in which we would, try to identify who might actually be a relevant comparator and try to narrow that sort of thing down. And then at that point, we really try to respect as well the privacy of non-parties. So, if you're asking for information about whether comparators have made similar complaints of discrimination, that's the sort of thing that we're certainly happy to look into, and we're certainly happy to work with opposing counsel and identify what might actually be reasonable. But we want to be considerate as well of the fact that we have non-parties to this litigation that you're potentially asking for very sensitive information about. And so that's a situation in which we would certainly work with opposing counsel to try to find out what might be reasonable.
Thank you. Judge Coulson, what in your view, I want to get a sense of your view of the propriety of an employee seeking other evidence on how an employer treated comparators?
When you say other evidence, do you mean
how they treated individuals, let's say, that maybe the plaintiff says were treated more favorably than the plaintiff, as an example, or disparately from the plaintiff in some way in order to draw an inference of discrimination?
Well, look, to kind of pick up maybe where Lauren left off, you've got to make the case for me. So if you just say, look, so-and-so was the boss's favorite, that doesn't really help me. If you say, I'm the only one whose FMLA request was denied of everybody in my group, then maybe we start to look for that kind of data from comparators. But, you have to be careful. It's kind of like the quote unquote other similar incidents, right? We don't want to get into kind of a second shadow litigation about whether this comparator's experience was the same or different from yours. So I'm really looking for a pretty well thought out argument as opposed to a knee-jerk one that, so-and-so was in the desk next to me. I'll bet there's something that, she was given that I wasn't. That's probably not going to do it.
And it sounds to me as if in that argument, we need to be thinking about temporal proximity and other appropriate limitations.
Yeah, to me, same group, depending on how the company is structured. So, if you work in sales and you're looking for complaints from somebody who works in accounting, in a 5-person company, maybe, but in a company of any size, probably not, right? So we're going to define comparators relatively strictly, but also take into account the overall nature and size of the operation.
Thank you. Judge Davis, what is your view of the propriety of an employee seeking to view the file of an alleged discriminator supervisor to mine for other acts type evidence?
I'm trying to figure out why you would have to view the file instead of just ask for that information. This is where we as judges sometimes say, sometimes, most of the time, actually, when you are writing a request, what you're seeking. But somehow it doesn't make it from the brain to the piece of paper or the typewriter or the computer, because the request comes out generally a lot more broadly than what you were thinking about what you actually wanted. So what you actually want, ask for that information and you'll probably get it. If you want A and you ask for A through Z, you're going to have a discovery dispute. And then you're going to be required to participate in the process of good faith meet and confer and all of that, because it's just like medical records almost. An entire file contains a lot of information. And so you have to, and when you ask for it, you have to be very specific. Disciplinary action concerning what? It has to be related to the elements of the claims that you have. People can be disciplined for a lot of things. And as an employee or a supervisor, but it has to be more related to exactly what the claims are. If it's racial discrimination, maybe sometimes even more than that, discrimination based upon the fact that, and then you ask for that, and then they can go to the file and get that information, because asking for the entire file, generally speaking, is, at least in this judge's view, assuming that if you ask for the information, the other side is not going to provide it to you. It's like assuming that someone is going to be untruthful. if that's your assumption, you better have some proof to back it up before you get anything like an entire file, because otherwise we have to presume that during the process, people are going to conduct themselves as the law requires, and that is provide what they're asked for, of course, unless they have an objection.
Thank you. Andrew, I'd like to turn to immigration status. So how do you respond to requests for documents or other information about your client's immigration status?
For the most part, it shouldn't be relevant to any of our cases, unless, of course, it is relevant. And, you know, in the irrelevant part, you know, our statutes, Title VII and DCHRA and others, you know, protect individuals regardless of their immigration status. And so the fact that an individual is has work authorization or not is, you know, irrelevant to the facts of whether they were discriminated against on whatever basis. I mean, you know, recently we had a case where a client who was undocumented was fired, we argue pretextually for that reason, because she was undocumented. And, you know, then it became, you know, predominant and center focus of the case because, you know, our belief and evidence show that the workforce predominantly hired undocumented workers. And so that was something, you know, the other side resisted producing evidence of, and we really had to push for and go to the judge, go to the court to compel, and we're successful on because it was a central fact and focus and relevant factor in the case. Otherwise, it shouldn't be touched, and we would, you know, wholeheartedly push back with all of our might to producing that information.
Lauren, workplace investigations, how do you respond to requests for documents or other information relating to any workplace investigation that your employer client conducted into, let's say, a individual employee's retaliation case where, you know, what the employer did and might arguably be relevant?
You know, Scott, obviously, I think the most important criteria for us, at least initially, would be whether or not that investigation was done by an attorney and might potentially be subject to attorney-client and or work product privilege or doctrine. You know, beyond that, if it is not protected by attorney-client privilege, you know, that's certainly information that we would be willing to produce. You know, in a general case, obviously there might be circumstances in which that is not the case, but nothing comes to mind presently. You know, and certainly we would hope that there might be a situation in which the factual conclusions, even if it was subject to attorney-client privilege, where the factual conclusions might have been separate from any kind of legal conclusion, such that we might be able to produce that information. But certainly, obviously, it's something that we would generally find to be relevant and worthy of production.
Thank you. Let's turn to depositions. Judge Davis, the Eastern District of Virginia standard discovery order includes a 5 deposition limit. Does that limit include experts?
No, that's in the initial scheduling order. It actually says 5 non-party, non-expert depositions. So the real issue in most of those incidents is what's a party, you know, because a lot of people want to then say, well, every employee is a party, so we can take 30 depositions of the employees, and that's just one deposition. And once again, at least in this courtroom, you have an uphill battle because that's a difference between, I mean, the rules a lot make that kind of clear when you start talking about who's a party. I mean, it starts with officer, director, managing agent type thing, you know, people who have some discretion in making decisions rather than just following orders. But yeah, that's where the sticking point normally comes, is who's the party, because the initial scheduling order is quite clear that it's 5 non-party, non-expert witnesses or depositions.
And if, let's say, one or the other party wants to take more than the 5 depositions, what is the information that you want to see in that motion in order to feel comfortable with approving an extension beyond the 5 deposition limit? Well,
2 things. One, why you believe that information, well, three things actually. Why that information that you, well, first, what information do you believe that you can get from that individual? Why don't you believe you can get that information from someone who's in the 5 non-party, non-expert depositions? Because if you don't think you can, maybe you're putting the wrong 5 people's name on your list to depose, and you should think a little harder about who you should be putting on that list. And because, of course, you know, you always and is it more factually based, or is it more based on policies and things? Because you obviously get you can get a 30B6 witness who can limit all of that and give you a company-wide, company-wide policy and binds the entire company. So the individual witnesses themselves and their statements may not be as important in proving the elements of your case as the company binding itself on what that policy or whatever it may be. But it has a lot to do with that and timing, because the next question out of my mouth is going to be, as a judge, and so you've already taken those other depositions and you have not acquired that information. So you feel the need, because otherwise, then why isn't your motion premature? Because you can't explain to me why you don't believe you can get that information from those other individuals if you have not yet tried.
How would a party best seek leave of court, Judge Davis, for more than 7 hours of deposition time with a fact witness?
It will be similarly based. And that may be even tougher, because the first thing I'm going to do is look at you and say, I'm quite sure that as an experienced, competent counsel, 7 hours is definitely sufficient enough time for you to acquire the information that's relevant to prove the elements of your claims. Because otherwise, we should consider, spending a little more time in the preparation phase, narrowing those types of questions that we should be asking that can actually elicit the information that we want, rather than just going off on, general nature hunts and trying to get information, because it's the same way I would look at a request to, utilize more pages, because we have, briefing limits here for your memorandums in support of your briefs, 30 for the motion, 30 for the opposition, 20 for the reply. It's the same concept, because if you can say something in less words, don't use more. If you can get the information from a deponent by asking less questions, don't ask more. And 7 hours just seems like a lot of time to be asking one person questions.
Thank you, Judge Coulson. Where do you come out on this? How would a party best seek leave of court for more than 7 hours of deposition time from a fact witness?
That'd be a tough argument. And in part, I do, perhaps my judicial bias on this is I never took a 7-hour deposition in my life. I'm not sure I took a 5-hour deposition. In any case, over 25 years in private practice. But, could the case be made? Yes, the case could be made. For whatever reason, everyone is very efficient. Maybe there's multiple parties, multiple lawyers. This is a key witness. It's a 30B6 with 50 relevant documents. It's a class action, something like that. But generally speaking, that's going to be a bit of a tough sell. I'm with Judge Davis. If you're experienced counsel, you should be able to get your outline down if you spend enough time in prep. That's the old phrase. If I had more time, I would have written less. Well, if I had prepared more, I would have taken a shorter deposition.
Thank you. Lauren, let's turn to you and talk about the plaintiff's deposition for a moment. Lauren, you believe that settlement discussions are generally not fruitful before the plaintiff's deposition. Why?
I think you can certainly have some informal settlement discussions. I think that sometimes plaintiff's deposition is a very good opportunity for everybody to get in one place and really hear both sides. And I think sometimes it takes that sort of opportunity before everybody really understands what the plaintiff's case entails. And in my personal experience, oftentimes plaintiffs' settlement demands are significantly more before the plaintiff's deposition than after. And it takes the plaintiff's deposition oftentimes before people are willing to really start negotiating seriously. And so I think it's that sort of opportunity oftentimes that makes me think that settlement discussions are, and I'm not saying that they're not fruitful, but I'm saying that they're generally more productive after the plaintiff's deposition has been taken.
Do you videotape your depositions, Lauren?
Depends upon the situation. If the client can't be there for some reason and would like the opportunity to see the plaintiff during the deposition, then we would take the plaintiff's deposition. If we have reason to believe that plaintiff's counsel might be particularly difficult during the deposition, then we might take the deposition, or videotape the deposition. Similarly, if we have some reason to think that the plaintiff might be less than truthful or be challenging, or we might be headed for a jury trial. Those all might be situations in which we might want to videotape the deposition.
Do you prefer remote or in-person deposition?
I strongly prefer in-person depositions. I think that you get a lot more from taking a deposition in person. I also think that there are just intangibles that you gain. The opportunity to sit down in person with the plaintiff, to sit down in person with opposing counsel. Everybody sits around a table and has the opportunity to talk when you're off the record. I think that really goes a long way too, in terms of advancing both parties in the case.
Judge Coulson, how do you approach a dispute about whether the deposition should be taken in person or remotely?
So there's kind of a COVID answer, and then there's a non-COVID answer. So during the throes of COVID, when there were restrictions and concerns about traveling, being in the same space, etc., I would say I wouldn't say not quite the default, but most folks were agreeing to do them remotely. And if somebody was pushing for in person, I probably came down more on the side of remotely for kind of public health reasons. Now that we're kind of learning to live with COVID and other things, I would put the burden on the person who doesn't want it to be in person to tell me why it shouldn't be in person for the reasons that Lauren gave, and I'm sure Andrew would have some similar reasons, right? That you get a lot from being there, not just in terms of perhaps having a better deposition, but also, again, the opportunity to talk through the case with all the lawyers there, form some rapport perhaps to avoid some problems down the road, get a good sense of how the plaintiff or the defendant is going to come across in cross-examination on a witness stand. So that's kind of where I am now. And I won't say post-pandemic, I'll just say now that COVID is just a part of our lives.
Thank you. Let's turn to the 30B6 deposition for a minute. Andrew, you like to use the 30B6 at the end of the discovery process. Why?
Oftentimes, I think, I think there are benefits to both. I'll start with that. But, for us, I think in my practice, it's been helpful to use a 30B6 deposition to really get the company's stance on facts or policies once we've had an understanding of the circumstances from really the fact witnesses and of the events. And once we've been able to distill, sometimes conflicting versions of the events from fact witnesses, to use the 30B6 to either clean up some of that information or further, diversify what the factual circumstances are. And really it helps to, we like to place it and typically place it at the end to really do some of that cleanup work of either information we haven't been able to get from the fact witnesses we've had so far, or to get an understanding of the defendant's understanding of what the relevant policies and practices are.
Thank you. Judge Davis, in your view, how has the new counsel meet and confer requirement changed when a party can seek court intervention on the scope of a 30B6, the scope of the 30B6 topics?
When they can or when they do? It's quite clear that until they try to resolve it in person or by telephone, then they're not supposed to come to court. So the real question is, what's the definition of that good faith? And a good faith meet and confer, I don't think differs whether you're talking about a 30B6 or whether you're talking about a fact witness. And I think that's why Ms. Adelman's approach in that regard is probably a valid approach, because you may rule out some of those 1 day, 7 hour issues and those types of things if you can acquire some of the information from, especially factually, from other witnesses than a 30B6, because then you can narrow the number of topics, you can narrow the scope of the topics. And so that's normally where you get the dispute from when it comes to 30B6 witnesses. So if you can get that information elsewhere, the 30B6 witnesses should be dealing with more binding companies, more on policies and regulations and how we do things, probably more than just facts, because they have to go somewhere else to get the facts anyway. I mean, we all probably understand in reality that a 30B6 witness is probably not going to personally have a bunch of knowledge about much of anything. So it's the individual who's prepping them who is going to be acquiring that information from other sources, or the 30B6 speaking to other sources to get it anyway. So in order to avoid most of those, and once you've done all of that, then the probability of being able to meet and confirm, resolve any disputes, because there'll be a lot less of them concerning the 30B6 witness, will probably be more fruitful than doing it the other way around.
So let's just say that the parties have in good faith met and conferred. They've resolved their disputes on most of the topics, but there are disputes on a few. Should they take the deposition, the 30B6 deposition, and then come to court, or come to court and then take the 30B6 deposition?
Well, I guess that really truly becomes what the issues actually are, because it's difficult to understand how you believe you won't get information from someone until you attempt to acquire it. Now, if the issue is you shouldn't be asking those questions, then it's difficult for the court to understand why to that, unless those topics are completely off the rails, because it's this court's determination that it's difficult to conclude that the parties have a right to unilaterally make the decision on what's relevant and that's not relevant. And that's when you usually end up in court, because our definitions of relevant don't seem to want to suit the definition set forth in the rules, which is calculated to lead to discovery. Generally speaking, plaintiffs' views of what's relevant are usually a lot more broad, and defendants are a lot more narrow. Once you understand that concept, you should understand that the judge is going to be more of a Solomon. And the majority of those orders that come out, probably, unless there's a very finite point of view to make or a very finite issue, is probably going to be to split the baby. And if you know that already, you can do that amongst yourselves in a true good faith meet and confer without filing any motions, because either you resolve it amongst yourselves, or I'm just going to resolve it for you. And trust me, both parties probably may end up happier if you resolve it amongst yourselves.
Thank you. Judge Coulson, where do you come out on this? Let's say that parties have met and conferred, they've resolved most of their issues, but there are just a few left, maybe a couple topics. Come to court and then take the deposition, then come to court. Which way do you lean?
So because of our informal and expedited process for resolving disputes, most of the time, I think there's the opportunity to come to court first, review the issue with me or one of my colleagues, and we can resolve it right there. The problem I get is this, and I hope everybody maybe takes a little note on this. There are a lot of things going on in the courthouse on any given day. And on any given day, I could be on criminal duty. I could be in the middle of a trial. I could be having a motions hearing. So if you call me on or write me and advise me on Thursday that the deposition is Friday, I may or may not be able to accommodate you. So in that circumstance, if practically speaking, there's not a realistic opportunity to get it resolved, then do what you can at the deposition. But I would hope that you could work it out. And if there is anything remaining, we'd have some time to deal with that. But to Judge Davis's point, remember, in many cases, we don't know anything about your case. We don't know anything about your business if you're the defendant. We don't know anything about your life if you're the plaintiff. And you're asking us to parachute in and to make our Solomon-like decision. You're much better off solving your own problems. You're going to have much more satisfaction all the way around. I can guarantee you, because we will in almost every case, do rough justice to the best of our ability with our limited knowledge.
So you mentioned the court's informal process to bring something before the court, a discovery dispute. Can you describe how that works?
Well, we're all a little bit different. So the local rule would say if you're going to have a discovery dispute, you are to exchange a motion to compel, for example, and a response and a reply amongst yourselves, meet and confer about it, and hopefully resolve it before you come to us. We all have a meet and confer requirement. Most of the judges on our court, however, have adopted a process where you alert the court to your dispute by a joint letter of about a page. That you then have one party submits 2 pages or 3 pages on the dispute. The other party responds within a couple of days. Then you have a telephone conference, and I'd say 90% of the time that does it. It's very rare for us to have to resort to formal motions and back and forth. It happens occasionally. It's necessary occasionally on some issues, but most of the time that process does the trick. And that's followed by, I'd say, the vast majority of the judges on the court.
Thank you. Judge Davis, what are the essential components of every motion to compel? And what do you expect to see in that motion to compel that maybe you don't see enough?
The specifics of what happened at that good faith meet and confer, because we're pretty serious about that rule. I mean, it's difficult to, and I feel that way a lot more because I would have to venture a guess that, or an estimate that probably in about 35-40% of the time when I get an inkling based on the first statements made by counsel at the motions hearing that a good faith meet and confer may not have occurred for whatever reason. And I send them out in the witness room outside, and probably 70-75% of the time they come back in and say, we resolved disputes. So in a motion to compel, I need to see more than the certification that says we met and couldn't resolve. You need to say some things like how many times we met. Did we meet in person or by telephone? I mean, what issues or how many issues were resolved? How many issues were not resolved? Because you need to show that what needs to be compelled, you could not resolve. And if the court needs to get involved, you need to prove truly why it needs to be compelled, rather than parties just agreeing to it. And then the final thing is, don't ask for sanctions unless, it's simply because the parties or the lawyers have a disagreement in regards to the interpretation of the law. I mean, that is a substantially justifiable basis to file a motion if you truly couldn't resolve it. That's why we say resolve it amongst yourselves, because if it's completely just not, if there's a statute of limitations or something to that effect, obviously that's completely wrong. But if lawyers disagree on the interpretation of the law or the application of the facts and the law together, you probably can resolve it. And so, and here's a big one. Simply because you filed the motion, the rule says nowhere in there that all meet and confer cease to happen post-filing. Because once you file the motion and or an opposition and or reply, you can still meet and still resolve.
Judge Davis, thank you. Judge Coulson, what are your pet peeves in discovery?
Well, one of them is a version of what Judge Davis just described, which is the meet and confer will be an attachment, and it'll say something like, on Monday at 6:42 p.m., I sent an email to the other side and told them all the stuff I wanted, and they didn't respond by the next morning, or they responded and said no. So we've met and conferred, and now you've got to solve our problem for us. So some version of that. That's obviously a little extreme, but not too extreme. Honestly, I see that kind of thing all the time. Email is a terrible way to try to satisfy anything. It's just people say all kinds of things on email. Get on the phone and try to solve your problem. In terms of other pet peeves, don't call me from a deposition. Again, my ability to deal with you on the fly is very limited, and my ability to be up to speed on whatever just occurred for 2 hours at the deposition is very limited. So do what you can, bring it to me later. On written discovery, if I see these boilerplate objections, you're just telling me that your client doesn't have the ability to answer these questions, or you didn't do anything by way of diligence as counsel. So if every question has an objection, and if everyone says, notwithstanding these objections, here's some stuff, you figure out if I held anything back, that drives me a little crazy. What I would suggest to counsel is, if I'm your discovery judge, get on Westlaw, pull my discovery opinions, and you'll see what I don't like, because I'm not too shy about letting folks know, and they may not, most of them probably aren't published opinions, but you can find them on there. You'll get a good sense of things that get me a little riled up.
Thank you. We're almost ready for final thoughts, but Judge Davis, I'd like to turn to acts of professionalism between counsel. Do acts of professionalism in briefs or in person have an impact on you as a judge?
The honest answer to that question is they shouldn't, but we're human. Judges are human like everybody else. We're not made of steel. I mean, if that literally was one of the things that disappointed me the most from doing so much work in the criminal arena and then becoming a magistrate judge and doing civil motions, because I found out quite quickly that civil litigants, or many civil litigants, for some reason have an ability to lack civility. And I never understood why, because unlike criminal, when freedom and lives are at stake, we're just talking about money. And the rules are quite clear that you're to respect the professional decorum, and that means not only of the court, but of opposing counsel. You never accuse opposing counsel of doing something that can be interpreted as either unethical or illegal, unless you have some serious proof of it, because everything that happens in that courtroom is taken down for all time. And it may end up in front of someone that could negatively impact someone's career. We shouldn't do that lightly.
Thank you. Judge Coulson, acts of professionalism in briefs or in person, does that have an impact on you?
Yeah, it does, right? Because if I'm trying to be reasonable, if that's my goal, I'm trying to get to the right answer, and I'm trying to get to a reasonable answer. You're facilitating that process if you're coming to it from a point of reasonableness as well. And I think subconsciously, you're going to earn some points with most judges, if you are the more reasonable party. All those emails that you fire off to the other side, they're all exhibits, right? So, you think that you're solving a problem by sending a zinger to somebody at 7 o'clock at night. You're just digging your hole deeper. So it definitely has an impact, the tone of things. And when I see negative professionalism, which I do see both in writing and in person, it really sets a tone, but not in a way you'd like. If you call, another pet peeve is when you call opposing counsel disingenuous, because that seems to be the what folks have judged to be the safe word for calling somebody a liar. You're still calling somebody a liar, and I don't like it. Now, if they are a liar, okay, but to Judge Davis's point, you better have some good proof in the record. So yes, you're trying to put your best foot forward. It's a little bit like a job interview.
We are ready for final thoughts. Andrew, start us off.
I just want to pick up on something that Judge Coulson said earlier about, boilerplate objections. And, the problem that they frustrate me, aside from the fact that, they're not allowed under the rules, is that, it doesn't tell me anything. As much as I love to believe that our discovery requests are perfectly well crafted and reasonable, I understand that opposing counsel often has a different view. And if you're objecting to them, tell me why you're objecting to them. Tell me what's the problem, what you are producing, and what you're not producing. Because that really helps to cut down, after I get the objections, I'm writing a deficiency letter. You're going to write a response. We're going to get on a phone. We're going to have to draft a letter. And I really think that cuts down a lot of the attorney time and the dispute that, may, with that sort of explanation and the time put in the objections, can really, cut down the efforts and cut down the disputes that we'll have to take before the judge or the court.
Andrew, thank you. Lauren, final thoughts.
Thanks, Scott. Yeah, I think it's an adversarial profession, but all of our encounters certainly do not need to be adversarial. And I think that, in my experience, the best cases to work on and the best outcomes tend to come from cases where opposing counsel can work congenially together. If you have an issue, bring it to me. Let's talk about it. Let's have, an honest, frank conversation about what you actually want. And I'm willing to be reasonable under those circumstances, but it's very challenging. We all know those cases where you get an email and you're like, oh gosh, it's this case again, sort of thing. And it doesn't do anybody a service when that's the situation. So I think, the topic of this panel has been a good one. And I think it certainly makes sense if we can all kind of work together. It certainly leads to better outcomes for everyone.
Lauren, thank you. Judge Coulson.
One thing that is going to sound very old-fashioned, but really worked for me when I was in practice, and to the point where I don't know if I had 10 discovery disputes in 25 years, but when I got a case, if I didn't know the lawyer on the other side, I would call up the lawyer and say, hey, let's have coffee. And maybe that was our 26F or, whatever conference, but, a face to a name, the chance to have some rapport, the chances, they got their kids' pictures in the office. Oh, you went to, Towson University too. I mean, all those things, you're not, advocacy doesn't mean argument, right? Advocacy means getting your client as much as what you can under the rules as possible. And sometimes the most effective way to get that is to have a good working relationship that's going to spare your client a lot of expense, a lot of motions practice, and it's going to get them most of what they want and going to put you in a good light in front of the judge.
Judge Coulson, thank you. Judge Davis.
I would have to say the basis behind this entire discussion was how to avoid discovery disputes. We crafted the rule in the Eastern District of Virginia to try to avoid at least bringing them to court based on the good faith meet and confer rule. The philosophy behind avoiding discovery disputes is the same behind the philosophy that was there when we drafted the rule. Good faith meet and confer, I always tell people, it's like a settlement conference. It's about compromise, pure and simple. No one's going to get everything they want, even though we want it. You have to have the ability to understand, because if you don't compromise, the court will compromise for you. It's just that simple. And since you understand that, you should be willing to compromise in the good faith meet and confer.
Judge Davis, thank you. I want to thank Judge Mark Coulson, Judge Ivan Davis, Lauren Goetzl, and a special thank you to Andrew Adelman, who organized this webinar for us. For more about the Federal Bar Association Northern Virginia chapter, go to www.fba-nova.org. For future programming from the Metropolitan Washington Employment Lawyers Association, you can find us at www.mwela.org. Thanks for joining us today.